of this hour when I have the segment to myself to talk with you directly. Let's go right now to one of my closest friends in the world, just the legend. My kids call him the Savage. You know him, the OG, Alan Gottlieb himself. Mr. Gottlieb, welcome in. How are you today, my friend?
I'm great, Mark. Thank you very much for having me on today. I greatly appreciate it.
Well, thank you for being here on a holiday weekend. I do appreciate it very much. And, I get a lot of questions. Where's Alan been? Where's Alan been? I said, hey, we're giving Alan a break. He'll be here soon enough. So we're going to move quick with you. The segment flies right by. You and I have a couple, three things we want to cover. And that, Alan, of course, being, let me just lay this out for you, ladies and gentlemen, where we're going. But that's the recent win in the Second Circuit in New York, the Virginia suit that SAF is spearheading in federal court with the NRA and the FPC, and, of course, now the newest amicus filed by the SAF in Maryland. This is nonstop action, Alan. We are on a roll, and, I mean, we're watching positive changes as far as I'm concerned. We're seeing everything change right before our eyes. Let's talk about it. The microphone is yours, sir.
Okay, I want to apologize. When we talked earlier, I emailed you. It's not an amicus brief that we filed with the U.S. Supreme Court. It's actually another case at the United States Supreme Court.
Correct.
Actually, a cert petition. But before I get into this, two things I just want to cover real quickly, if I can. The Citizens Committee for the Right to Keep and Bear Arms next Saturday, May 30th, is holding a New England Firearms Advocacy Conference just outside of Boston. There's still a few seats left, so if some of your listeners in that area of the country would like to attend, they can get tickets for it at ccrkba.org/FAC. That's ccrkba.org/FAC. It's an action-packed conference with about 20 key speakers. John Lott's going to be speaking at it as an example of who your listeners are very familiar with. And so I just wanted to get that out. And then one other real quick thing, because I got visited last week on Friday. Ray Skagen, one of your really great listeners, who's the former retired assistant chief of police in the city of Seattle, came by the Second Amendment Foundation and left us a very generous donation for our legal activities. And I want to acknowledge him and let you know you've got a former police chief in the city of Seattle who's one of your main listeners forever.
Yeah, Ray's a hero, man.
Ray's a hero. I just wanted to let you know that.
Thank you, Ray.
Now going to those three legal entity things we're talking about. Our Second Circuit victory in the Christensen case, we won that at the court level, and it was on appeal by the state of New York. Letitia James just took it in the shorts. The appeals court ruled in our favor, and the so-called vampire rule in New York, saying that you can't, even if you're licensed to carry, you can't have a gun on private property that's open to the general public, like a supermarket or, a gas station. That's struck down at the appeals court level now, and I doubt if New York's going to try to appeal that to the U.S. Supreme Court. So that should be a final decision, and that anti-gun law in New York is now ashes. The other thing with Virginia, we're spearheading a case in federal court against their latest barrage of anti-gun bills they passed, which includes ban on semi-automatic firearms and magazine capacity. And we're proud to do that. We're partnering with the National Rifle Association and the Firearms Policy Conference. And that's a major case. It's got a lot of publicity. What's interesting, Mark, is a lot of the legacy media that never talks about when we file a suit carried the fact that we filed this suit immediately after the governor signed it. The amount of press we got nationwide on that is at an all-time high for any of the cases. When we first file a case, of course, we get publicity when we win them, but we don't get the publicity when we file them. We did in this particular case, though. And then, of course, the big news is that we just filed this past week a cert petition at the U.S. Supreme Court challenging Maryland's so-called sensitive place legislation, similar to the one we just struck down in New York. So we have a case, that one going to the U.S. Supreme Court right now as well. So those are like three of the more than 55 current cases we've got going on in court. It's been a very, very busy month for the Second Amendment Foundation.
Yeah, Alan, let me go to the Fourth Circuit now. John Comerford from NRA was on the broadcast the day after, or that weekend that it was filed, and I have to hand it to you at SAF. I mean, this case was, correct me if I'm wrong, was filed within minutes of the signature on that bill. late, wasn't it?
It definitely was. We were prepared for it. We were all waiting for it. As soon as the governor signed it, we were in court.
Now, that's a federal case. Let's talk about the distinction and the nuance between the federal court case and the state case. And we've already lost, Supreme Court failed to take that Snopes case. When they failed to take that Snopes case, the Fourth Circuit, that means that the assault weapons ban in Maryland stands. Now here we are again, same circuit. How's this going to work? What's the strategy here? Would you explain that to us? And then maybe compare that to the state court, because this is a two-pronged approach. We're outflanking this governor.
Yeah, let me rephrase it a little bit here. One of our problems is that we have so many cases. I think staff has 3 cases pending cert at the Supreme Court right now. They heard one case this year on the sensitive place law challenge for one in Hawaii.
Yeah, the Wolford case.
One of our problems is that we know the court isn't going to take a lot of gun cases at one time. Like maybe you're lucky and you get one, and we've got a whole bunch of them piled up, and a whole bunch more ready to go in case they don't take the ones that are already petitioned for cert there. And so we can't move them all at one time, but we don't know which one they'd want to pick. So we're sort of forced to bring as many as quickly as possible, no matter what. So the strategy here is really, I guess, based on the fact that we don't know which case they'll take or when they'll take it, but we're going to make sure they're always sitting in front of them, and that somewhere down the line they'll progress and take one, then take another, then take the other one. But we're not going to get them all there at one time, and it's disturbing to me because it costs a lot of time, a lot of effort, a lot of money to bring these cases, and we know they're not going to take them all, at one time, but we don't really have a choice. When our rights are attacked, we're here to stop that, because as I always say, a right delayed is a right denied.
And we've got to stay in front of the court, ladies and gentlemen. We absolutely have to stay in front of SCOTUS, and the Second Amendment Foundation has been there, as I've told you many times over many years, and Alan has reiterated this, over 85, and it's probably higher than that now, probably closer to 90% of the cases won across the country come from the Second Amendment Foundation. Alan Gottlieb, thank you for being here on a Memorial Day.